a, I guess, rule changing bill, whether that be constitution or operating procedures or compiled code, it would have to have that appendix upon submission. And so this just would essentially just go under our same format guidelines. And so this would just be an addition onto those. For example, we already require that you have like an author summary and a long title and whereas clauses and other things. And so this would just be another thing that is already sort of an expectation, but not necessarily a hard rule. And so this would just make it so that you have to now. Just sort of standardizing that procedure across all procedural resolutions. So, yep.
Is there any questions for the sponsors? Representative Neal, go ahead.
Yes, Rep. Torres and Navarra, thank you for writing this bill. This is important. I am just wondering why we are leaving it up to the speaker to solely determine if the appendix is complete before it even goes to committee, because I can envision a circumstance where a resolution appendix is not able to be completed by the speaker's submission deadline, but it will be added to before committee. So then I think it should be able to be discussed as long as it is in order by the time the committee meeting starts.
So the thought process there was essentially that this is just essentially the easiest way to do this, since we already have the process for essentially this would just okay, let me just restart. The speaker already has the ability to rule something out of order if it's missing like an author summary or other formatting guidelines. And so the easiest way to sort of plug this into our existing compiled code was just to, or sorry, operating procedures was just to add it to the exact same language. I understand the concern there, but I think we run into the issue of sort of, currently I'm fine if we wanted to set the speaker deadline in like the operating procedures. So you can't make it, Wednesday right after a CSG meeting, and then it's a week, a while until the next assembly meeting or committee meetings. But I think my concern is, right now the way it's sort of set up is, for example, like finance committee agendas have to go out 1 p.m. on Saturday. And so there's a very short window there where people are not already looking at them, and people won't have time to generate useful feedback on a bill if it doesn't have any appendix. So I understand the concern, but the reason it was done this way is because it's using the existing framework that we already use for formatting guidelines.
Thank you. That makes perfect sense.
Oh, also, so sorry, my bad. Representative Cerrito is recording today. Just another reminder of that as well, because I believe that he did post it in the Slack, but just another reminder for anybody else who's not aware. Any other questions for the sponsor?
Hello, can you guys hear me?
Yep.
Oh my God, thank God. Apologies for that. Technical stuff. So I have a lot of questions. I guess first and foremost to the sponsor, what was the, like, why did this bill come into existence? People can hear me, right? Hello?
At least for me, you just cut out after you said why, and then it was a big pause. So
sorry about that. I don't know what's happening with my mic. Sorry, I'll repeat it. I was just wondering why this bill exists. Like, what was the thing that made this bill happen, other than like literally typing it?
I think there was an issue with or there was an issue with committees being slowed down by not knowing what um, bills were there for, or kind of, they just have the author summary and the resolve clauses, but they don't necessarily have anything else to go off of. And so people are kind of just sitting around, and it really slows the progress of committees because people aren't able to properly review things. And so I think that was kind of the primary issue.
I have another question.
Go ahead, Representative Burrito.
Can you be more specific? Like this is very vague. Just say like the specific bill. I'm confused, and I think my viewers are confused too.
I would have to pull up the exact resolution number, although I believe, to my recollection, there's been at least 3 bills this semester that have had this issue. And I've been in the rules committee meetings for each of these 3, and it takes a while for people to even understand what's going on, and it slows people down.
Well, I guess I'm going to motion to recess for 2 minutes so you can find the bill, because I don't think we should be passing anything if we don't know why we're doing it. So I'm going to motion for a 2-minute recess.
Is there any seconds? John, is that a second?
Yes.
Okay. We will reconvene at 10:13.
Actually, I guess since we have an opportunity, can somebody like help me with my audio? Like, is there any breaking up? How do I sound right now?
No, we can hear you fine. I can hear you fine.
Okay. What did it sound like before? Like Nico, or actually, you know what? Don't talk to Nico because he's looking the bill up. What did it sound like before when I cut out? Like just robot-y or nothing?
You did not cut out at all from my
It's
end.
so weird because everything on my end is perfect. I have no idea what's going on. Maybe my cable's rotted or something. Like that is something that can happen, is your cable can rot from the inside, and then you could literally try everything and buy like a $500 mic, and it's just the cable itself, which is like $20. So anyways, just let me know if it happens again, and I'll figure stuff out. I have a backup mic that's even crappier, but if it works better, I'll switch. Appreciate you guys. Oh my God.
So this is not the only example, but AR 16-003 had that same
Hold
issue
on,
where,
hold on, Representative
sorry,
Navarre. I appreciate
thank you.
it. The time is now 10:13,
Yes.
and I do call this meeting back to order.
Yeah.
Representative Torres de Navarra, did you find the resolution?
Yes, I apologize. So 16-003, so if you go to the tracker, it's the 3rd one. And that one there's a few more, but that was the first one I found. So for example, this one has a pretty extensive author summary that says what it wants to do, and then the appendix has nothing. And so my understanding is I think this went to 1 or 2 rules committee meetings where members were essentially wasting time on a resolution that they didn't even know what it did because it doesn't have anything in the resolution. So again, I think I understand that people kind of want to work in a collaborative manner, but you can't work in a collaborative manner if the resolution doesn't have anything to begin with. So it's kind of a chicken and egg situation there, if you will.
Representative Burrito, do you have a question?
Yeah, sorry, I must have missed it. What specific bill were you talking about that was not finished?
16-003.
And what was the title of that bill?
Phenomenal nominations, changes, and rearrangements.
Thank you for reading that. And so I'm wondering, you said that CSG is collaborative, correct? So I'm wondering
Well,
after.
I think,
Oh, sorry, my apologies. The speaker's supposed to be chairing.
the goal is to be collaborative. I think sometimes we maybe fall short of that, but that's just sort of that is the eventual end goal. Yes.
That is not my experience, but I hope that is true. So, in terms of this resolution, I have a different question on the more technical side of things. So, what do you define complete as?
If the bill matches what the bill says it does, rather than not having anything in the entire appendix section. And so you can't write half a bill and then submit half a bill and then expect people in rules committee to understand what half a bill means. It needs to be in some level of completeness, and then people can then go in and say, "Oh, Rep Nico, you missed this one thing. Did you consider this? Oh, let's add an amendment on that." That's getting it closer to being a good bill that people can vote on. That's what committees are for. But committees can't work if people have nothing to even go off of when they get there. So that's the whole goal of this resolution.
Madam
Representative
Chair, I
Neely.
do have more questions, but Miss Neely has her hand up.
Yes. Representative Neely, please go ahead.
Yes, I'd just like to remind everyone that we have a lot of resolutions to get through, so please be cognizant of time. It's not productive to ask the same question over and over again. Such
Point of order,
discussions
Madam
should be
Chair.
had on the
Point of order,
Slack.
Madam Chair. I did not ask the same question, and I would like to ask you, Madam Chair, did I ask anything that was redundant?
You didn't ask anything that was redundant, but you did ask questions that ended into another question, basically.
Gotcha. My apologies. I'll try not to do that again. But like I said, this is an important bill, so let's, for one, not point out that we're wasting time, because then we're wasting time pointing out we're wasting time. And let's talk about the bill.
Is there any other questions, Representative Neely?
Yes, please be cognizant that we have a lot to get through. And, out of respect for fellow members, let's keep it concise.
Okay. Representative Florito, please go ahead, but please, if you have multiple questions, this isn't really a debate. So if you have multiple questions, can you say them all together at once? So then we can just kind of go through them together instead of the kind of back and forth, can we do that? But you can please go ahead.
Point of parliamentary inquiry. So wait, what is the actual operating procedure about this? Like, if I have follow-up questions, I'm allowed to ask follow-up questions, right?
Yes, but you would have to raise your hand again, and then I would have to call on you, just to give other people more time. So then this isn't like a back and forth with just you and the sponsor. So then other people have a chance to speak as well.
Gotcha. That makes total sense. Thank you for explaining that.
No problem. Please go ahead.
Anyway, so I wanted to ask about, so you said the completeness is about the appendix, and so I guess I have a bunch of questions and scenarios about that, and I will try to keep it at 3 so we don't lose track of the questions, because these are important. I know everyone here thinks these bills are just a waste of time. My questions are a waste of time, but these are really important, so I would actually advise this committee to pay attention. So in terms of completeness, you said it's an appendix. Could you see a scenario where a speaker says one appendix is not enough and you need more, and they could rule the bill out of order? And my follow-up question to that would be, how many appendixes is enough? Let's say you're amending something where it's written in both the standing rules, potentially operating procedure, and also the compiled code. What if the speaker says you didn't do enough? And I guess the third question for that, and we'll keep it here for now so that you can pay attention, is I guess who decides, other than the speaker themselves, how many appendices are enough?
So just to answer kind of the general question, if something's amending, and this has happened before, something is amending both the operating procedures and the compiled coding, or operating procedures and the standing rules or constitution, etc., it would have to have multiple appendices. A single appendix can't refer to multiple different documents. That's traditionally how I've understood it to work. And so I think in the first instance, that would have to naturally be multiple appendices. I think the way if a speaker is potentially perceived to be unfair towards a specific resolution that's not meeting this requirement, that people are welcome to essentially object to that point of order, or sorry, not that point of order, ruling it out of order, which is what they can already do if a speaker doesn't think that the long title is sufficient or the author summary is sufficient or any of the other restrictions that we currently have. And so, yeah, I think this is a pretty basic sort of responsibility of the speaker, just to maintain progress and timeliness and just respecting people's time on weekends particularly. So yeah.
Representative Buckout, did you have your hand up?
No, it was answered, so we're good.
Okay. Representative Neely, please go ahead.
Yes, I call the previous question.
Are you motioning?
Yes.
There is a motion on the floor.
Point of
Is there a second?
information, is the chair aware that if we call the previous question, then we can't amend this?
Yes. Representative Torres, is that a
I'm good.
second? Okay. There is a motion on the floor. Is there a second? With no second, that motion does not pass. Representative Florito, please go ahead.
Also, point of information to the chair. Is the chair aware that if you don't want to be here, you don't have to be?
Who, point of information, who are you saying when you say chair?
You're chairing this meeting, are you not?
Yes. Are you speaking to me? I'm not doing anything.
No, I'm not. Let me clarify. A point of information is directed to the chair. Okay, I guess this is a point of order inside of a point of information. A point of order, a point of information is always directed at the chair, even if the point of information itself doesn't necessarily apply to the chair, if that makes sense. And in this case, it does not apply to you. I'm just pointing it out there that anybody who doesn't have, other than the chair and the vice chair, doesn't have to be here. And so I don't know why we're rushing through important legislation.
Okay, but let's not be rude about it, because some people are here just to listen to other things. So
I'm
let's
here to
just
do
be a little
business,
bit
Madam
nicer.
Chair.
I understand that, but let's just be nice about it, okay?
I'll do my best.
Mr. President, please go ahead.
I actually have a point of information for the chair. Does the chair know that making points of information while talking about other people and directing the chair multiple times each meeting could be interpreted as antagonistic while possibly not intended as such, and that members should try to restrict their questions to genuine, common, good faith debate through raising their hand? Is the chair aware of that information?
I am aware of that information, which is why I was trying to nicely explain this.
Thank you.
Thank you, Mr. President. Representative Florito, please go ahead.
Thank you, Madam Chair. And I hope that we can just actually focus on the bills instead of just interpersonal nonsense. So anyways, in regards to this bill, you answered my questions for the most part, although I think it could use some tweaks. We have much bigger fish to fry, in my opinion, because you said at the end of the day, in this bill, as far as I'm reading, it's up to the speaker. I can tell you firsthand in the last 6 months that we have had speakers, not that I blame the speaker themselves, because these rules are not very clear. Like in the Constitution itself, although the Constitution is the most clear of our documents, the compiled code and operating procedures, where people literally make unconstitutional rules and they pass them and the speaker doesn't rule them out of order. And so my question for you, I guess I have two, is do you see that being an issue here where a speaker, I'm not saying Devin, I like Devin, Devin's a good guy. I'm saying a speaker in the future could say something's incomplete just because they don't like the person proposing it, or maybe they're in an opposing political party. And the second question to that is, would you be friendly in terms of amending it to like include that and make sure that we cover our bases?
So is your question that a bill, sorry.
I'm sorry, is it a formal motion?
No, it's not. It's a question. You told me to make questions
Okay.
together, so not yet, at least. We'll come to an amendment after we speak.
So is the question that a bill was passed or a bill was rejected, ruled out of order, or a bill was passed and it was unconstitutional? Is it the first or second?
Madam Chair, am I allowed to respond, or are we not doing debate? I'm very confused.
You are allowed to respond to clarify your question, not to add anything new to it.
But wait, timeout. Point of parliamentary inquiry. How am I supposed to clarify my question if I can't add anything new?
I mean, in clarification, in the way where you don't add a new question into it or change the language in a way that makes a new question.
Gotcha. Thank you. Sorry, Representative Torres de Navarro, can you repeat what you just said briefly?
Were you referring to a bill being ruled out of order that was essentially valid, or are you referring to a bill that was passed and it should have been ruled out of order?
Honestly, both. I like I've said before, the
Okay,
last
so-
6 months of the hold up, I'm clarifying. The last 6, I wanted to give you a specific. The last 6 months of the assembly have had honestly an unprecedented level of unconstitutional bills, in addition to bills that were ruled out of order, like the $15 minimum wage, which literally that is the identical bill that passed in 2022 when we increased employees last time. That nobody, not the speaker or anybody else, stepped in and made a rule call. Or when they did make a rule call, it was an unconstitutional rule call. So I hope that clarifies it.
Okay, so we give the speaker certain powers within the Cloud Code, and then there's a check on that power, which is that the assembly, the voting representatives that were elected by their constituents, can then vote to, overrule the chair. I don't remember anyone doing it in those instances, so clearly people didn't feel like it was a, non-valid ruling out of order. And they're the majority. That's the majority of student elected representatives. And so I think that's as fair as it gets there. That's the first thing. And then the second thing of bills being passed unconstitutional, again, no one made a point of order. No one asked us, no one, maybe the speaker's personal opinion was that it wasn't out of order. People, if they felt it was unconstitutional, they could have not voted for the resolution. They could have just voted no. And so I don't really see, again, what the issue is there. And then I'm reading your, that's just the instance. If someone made, wanted to overrule the chair's decision on the out of order decision, they could have gotten a majority of assembly members to feel the same way. They didn't, and that's just how things work. I don't understand what the issue is here. And I think this resolution is going to be seen by this committee for a second time. Amendments can be made at any time. I don't know why we are spending 30 minutes discussing like minutia here when this could be done, offline. And I think we can move on to more important things and save people's time on a Sunday.
Point of parliamentary inquiry to the chair. Based on the statement there, am I allowed to correct the record if there was something that is factually inaccurate in what was said?
Is it factually inaccurate based
It's not a matter
on-
of opinion. It's literally, what is it, the color blue or the color red?
Sure.
Thank you. So I wanted to correct a few things, although I'm going to ask Representative Torres de Navarro to clarify first. Are you saying that nobody made a what is it called, an appeal to the chair, or are you saying that the appeals to the chair were not successful?
I would like to clarify before you continue. You can only correct the record as long as it's in the bounds of the question.
Point of parliamentary inquiry. What do you mean bounds of the question? Like it doesn't add a new question?
Yes.
Okay, thank you. Sorry, Torres de Navarro, please answer.
I am saying that there's instances of both where sometimes the speaker would rule stuff out of order and no one made an appeal, or someone made an appeal and it was not successful, meaning that clearly a majority of the duly elected assembly members did not feel that it was against our governing documents to do so.
Gotcha. I believe we did have one successful appeal, but obviously that's minutia. I just wanted to point that out. And I have other questions related to this bill, in addition to an amendment but that's up to the chair to decide.
What would you like to do? I'm sorry.
I have more questions, and so I'm raising my hand.
Oh, Representative Torres de Navarro. Why are you raising your hand?
I still had it up from when I was responding to Mr. Pieroda or
Okay.
Representative.
Okay. Representative Florito, you can go ahead.
So you said a couple of things there, and I think that definitely helped me understand this bill. But I had a few questions about like the what is it called? The importance of the bill itself. So you said we got to move on to more important things. I guess my first question would be, are you saying your own bill is not important? And my second question is, do you not see the value in making ourselves accessible in committees, especially when a bill like this will be abused by a future speaker, at least in my opinion? Those are my two questions to you.
I wasn't actually saying, can I respond?
Yep.
Thank
Next
you.
question to you.
Thank you. I wasn't saying that this resolution was important. I was saying that this discussion, which is going in circles and is clearly meant to just waste time, is not important. And I think we're not
Point of order,
discussing a
Madam
specific-
Chair.
we're not discussing a specific
Point of
amendment.
order.
We're not discussing a specific item
Point
of
of order.
resolution.
Do you
Okay,
recognize this
okay.
point of order?
Point of order. What is?
Uh,
Everybody calm down. It's 10 a.m. in the morning. Everybody calm down.
It's 10:31, but regardless. No, point of order is he just said that these attempts were to waste time. Are you allowed to say that about an assembly member, especially when my attempts are genuine questions, in addition to the fact that every question has been different, not the same questions?
He may feel as though it's a waste of time. He is allowed to say that because it's not inherently, well, I guess it is against you. Representative Torres de Navarro, let's just be nice, everybody. Can we all be nice? This meeting will move a lot better if everybody's nice. It's 10:30 in the morning. Please, please, please. Okay.
Can I?
Representative Torres de Navarro, please continue.
Can. Thank you. My perspective was just that I'm someone who likes to discuss very specific things, and so if there's a specific amendment that we would like to discuss or a specific item of the resolution we'd like to discuss, I think we played through the hypotheticals on what this bill could be used for. It's using an already existing power of the speaker that then voted members of the assembly can vote to overturn. It's not saying that the speaker has the ultimate authority to rule every bill out of order and then they can't, no one can say anything. So that's just my perspective. I understand you have a different perspective. So perhaps we could propose amendments and move it towards a place that you would like this resolution more.
Representative Neely, please go ahead.
Yes, I call the previous question.
There's a motion on the floor. Is there a second?
Point of information, I literally wanted to make an amendment. I mean, she has the right to make that motion, but that's literally what I said at the end of my thing. I guess, is the chair aware that I said that?
Yes, but there's a motion on the floor. Andrea, is that a second?
Yes.
Okay. With that being said, discussion of Representative Torres de Navarro Assembly Resolution 1620 has ended.
No. Point of order. I object.
Okay. Okay. I'm so sorry. I forgot about that. All those in favor of ending. Oh my gosh, what's the word for it? Ending conversation debate, please raise your hand now. For everybody. John, did you get that?
Yes, please lower your hands.
All those against ending
Test.
debate, please raise your hand. please lower your hand. All those abstending, please raise your hand. Please lower your hand. What is the total, John?
Madam Chair, with a vote of 5-1 and 1, the motion to
These
please
people just do not like
is
debate.
adopted.
They just hate debate.
Continuing forward, I motion to discharge this to the assembly. Is there a second? Representative Neely, just to clarify, is there a second?
Yes, it is a second.
Point
Is
of
there
order.
any
What was the previous
objection?
motion that we just did?
That was to end discussion on the bill.
Point of parliamentary inquiry. Do we need to make that motion to end discussion?
Yes.
Thank you for clarifying.
Is there any objections? Is that an objection?
Yes.
Representative Maria?
Yes, Madam Chair.
Okay. Hand vote. All those in favor of discharging this to the assembly, please raise your hands.
Thank you for clarifying.
Low-key, everybody else who is in this Zoom, please make sure that you raise your hands for something. Did you get that, John?
Yes, please lower your hands.
All those who are against discharging this to the assembly, please raise your hand. Let me repeat, all those who are against discharging this to the assembly, please raise your hand. Okay. All those who are abstending, please raise your hand. Please lower your hands. John, did you get all that?
Yes, Madam Chair, with vote 4 yes, 0 no, and 1 abstention, this bill is discharged to assembly.
Okay. So continuing back to the CA 16002 constitutional amendment titled Protect Democracy. Sponsor, if you would like to introduce, please go ahead now.
Perfect. I just wanted to ask, how much time do I get to introduce?
3 minutes.
Thank you. So this bill, and I would encourage before I begin that anybody can actually read the bill and also listen to my introduction rather than just like, I don't know, playing Pokemon Go, although it's very addicting for me. And this bill itself is extremely important. Not only is it a constitutional amendment, which every constitutional amendment is important, but this one specifically is to protect democracy. And obviously a lot of people say, oh, I'm going to protect democracy, or insert so-and-so is a threat to democracy. But a lot of that is just words. What does this bill actually do? And for that, I would call your attention to the end under Article 8, Student Rights. Section 3, the amendment proposes, following fair regulation, this is the original wording, student governing bodies and organizations must not impose rules and regulations that are unreasonable or not fully and clearly formatted, published, and made available to all students to which they apply. So that's the original language, and this would add on to that. This also includes rules that may or may not violate superior governing documents but are sufficiently vague, even if the rule itself is ruled to not violate the clause itself. Why am I making this change? It sounds like a much ado about nothing, right? This change is extremely important because we have so many contradictions. Clearly, if you disagree with that perspective, I would love for somebody to ask me why or like make their case. But we've had, by my count, at least a dozen bills in the last year alone, or not even the last year, last 6 months alone, that conflict or at least are vague enough that we don't know what is even true about if the bill is unconstitutional or if it violates compiled code, if it's lower than that, etc. And that is an extremely big problem because I think it needs no introduction, but I will say it anyways. If we do not know which governing documents, especially superior governing documents, violate each other, it is impossible for our parliamentarian or deputy to do their jobs, and it's not their fault, of course. We just don't know what bills violate what. In addition to that, it also creates an issue for everyone else on campus because people forget that we also govern, to an extent, students in general and their participation in these institutions, not just by their fee, but also by requirements, what we can do with student org funding. And so if something is vague, not only does it create hell for CSJ and the courts, but it's also going to deter more people from getting involved. And I think it's no secret that after people have been kicked out of office or have been removed from elections after winning based on very vague or outright unconstitutional rules, that is a deterrent to get involved. And our turnout, like I said, is the worst since COVID. Since literally the whole world is shut down, our turnout is that low. Obviously, we always get enough soft C requests to give our whole budget away, but still, who knows? Maybe there's tons of other orgs that have been deterred. Maybe they applied once, didn't understand the rules, and just gave up. Maybe they found another source of funding, or they totally retracted their organization and it fell through. And that is something that cannot happen. And with this bill, we won't let it happen. I yield to the chair.
With 10 seconds to spare, is there any questions for the sponsor? Mr. President, please go ahead.
Yeah, thanks. Sorry, I was eating yogurt. So, the rule, superior governing documents, but are sufficiently vague, even if the rule itself is ruled to not violate the clause itself. So, I first, my first question is, even if your language is, even if the rule itself is ruled to not violate the clause itself, my first question is, who is ruling on the vagueness of the clause? And my second question is, if CSJ rules that a clause is not vague, does that nonetheless make it unconstitutional by this language?
Those are great questions, honestly, and I'd be happy to answer them, or at least do my best attempts, and feel free to ask me follow-ups if I don't answer them. So I think, first and foremost, who rules on it? Obviously, it depends on if it's a meeting. If it's a meeting, it's the chair of the meeting, of course. If it's in, what is it called? If somebody's being sued over a rule, obviously it's up to CSJ. And for any other sort of authorities, although I can't really think of any off the top of my head, it would be for whoever is designated that power explicitly in the Constitution or compiled code. And in regards to the second thing, so the whole point of this is not about the constitutionality argument. The reason why I put this in here, and this is so important, is if a rule does not violate another rule, but is so vague that we have to have a whole court case about it, it would violate the Constitution under this rule. And the reason why is, for one, it encourages people to be very specific in their rules, which is what we should do already. And I think it's no secret the past 6 months we've had an awful amount of vague rules or outright potentially unconstitutional rules be enforced for some reason. And so this would necessitate either directly in the bill amending process, or at least encourage in the bill amending process to ensure that that is not even a possibility. There's no vague anything. We are defining everything to the point where it's annoying. And I know that people don't want to waste their Sundays, but these is important. Treat it like laws. I know we're a student gov, but we got $2 million here. We got governing documents. Some of these have existed for decades. It's important. And so we need to take the time and do due diligence there. And the second part of my answer to that is that it would not, I believe you said it would be ruled unconstitutional even if it didn't violate the rules. It would depend on the situation, but largely I don't think that's an issue unless you could clarify your question for me.
Mr. President, go ahead.
Maybe I'm just reading the language wrong. The Fair Regulation Clause said that student governing bodies and organizations must not impose rules and regulations that are unreasonably or not clearly formatted, blah, 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 blah. Included in that restriction is bills that are ruled not to violate a clause of the Constitution. So I think you already answered my question. However, it is sort of confusing. I guess it's not really a question, it's more of a comment. I guess it is sort of confusing that if a court rules that it's unconstitutional, or if a court rules that a bill does not violate fair regulation, but it's interpreted to be vague anyway, I don't really understand. I guess I don't entirely understand what rules are and are not a violation of this clause, because I don't know what is and isn't vague, and I don't know who defines what is and isn't vague.
Madam Chair, could I respond?
Yes, please go ahead.
Yeah, no, I mean, obviously, I think the irony of having a clause about vagueness be vague is pretty funny. But regardless of that, you have to remember that this rule, as written, this also includes rules that may or may not violate superior governing documents, but are sufficiently vague, even if the rule itself is ruled not to violate the clause. And I apologize for this is on me. The clause I am referring to is the rule in question, not the Constitution. And I don't have language right now, but if you have any amendment language, I'd be happy to make it. The idea is that if a bill is so vague that we have a whole issue, then it would, whether it be up to the court or up to the chair of the meeting, they would get to rule on that. Although historically, chairs have not ruled things unconstitutional, even though they're supposed to. So it would either be the chair or the court still. And yeah, I see where the confusion is, and I guess I can sleep on it and figure out some amendment.
Representative Torres de Navarro, please go ahead. No?
I have nothing to say.
Okay. Any other questions or comments for the sponsor, excuse me? Representative Florido, are you going to ask yourself a question?
I wanted to make a comment. Am I allowed to do that?
Yes.
So in regards to this, since it's a constitutional amendment anyways, it wouldn't even pass until the certification of the fall election, assuming it even got the vote threshold. So I'm not going to like spend time right now, like I said, or like someone said, be cognizant of people's time. I'm just going to say that if you wish to both sponsor, endorse, but also amend this, please reach out to me. I don't bite, even though I am. I look angry, but I'm not. So please reach out to me. We have plenty of time, and although I do wish to pass this in the next meeting, obviously it's not going to take effect anyways. I just think that it would be beneficial for us to get something on the books as quick as humanly possible. So I yield.
Okay. I motion to discharge this to the assembly. Is there any objections? Is there a second? Andrea, is
Point
that
of
a
order,
second?
Madam Chair. I believe seconds come before objections.
Yes. Whoopsies. I'm very tired. Andrea, was that a second?
No, it was an objection because I wanted to ask a question.
Okay. And we have to go into a hand vote.
Point of information to the chair. I guess in theory, you could yield back for more time since I believe you made the motion to discharge.
I can withdraw my motion, and I will now withdraw my motion. Representative Bustillo, please go ahead with your question.
Thank you. So I just wanted to clarify again because just the wording of this is confusing me. But so the clause you're saying is what the rule. Okay, hold on. So the rule itself is ruled to not violate the clause itself. The clause is part of a superior governing document, or what is the clause part again? Can you repeat that, Representative Fiorito?
Yes, I will first start by saying I left a comment there so that obviously we have plenty of time before next meeting, in addition to potentially a whole nother month. If you have any language suggestions or anything, an epiphany dawns on myself or anybody else, just reply to that comment and we can make those language changes, or you can make the suggestion in the doc. And anyways, to answer your question, Representative Bustillo, basically what it is saying is even if like let's say court or the chair rules that the clause doesn't violate, it could still be unconstitutional if the clause itself doesn't explicitly state what like its intent is written as. So I can give a tangible example of this. So we have the operating procedures, right? And we have the Constitution. Constitution is more powerful than the operating procedures. I would give the example of the press ban, or not ban, of course, it's restrictions, whatever. That bill is written vague enough that it could allow a speaker theoretically to just never respond to a press inquiry because it doesn't have a timeline on it. So they could hold on indefinitely and stop anybody from doing a press pass. Thank God we have Devin. Devin's a good man, and he did respond to my request. But in theory, there's no rule that says he can't. And because it's vague, I would argue, and I think that our chairs should also interpret the rules this way, as they should be, is the student right fair regulation clause, in addition to the freedom of speech clause, is violated by that rule because it is so vague that in theory, the speaker could literally just never respond to any press inquiries they didn't like. And so that would be one example. There are plenty of other examples, and God knows I haven't even read all the governing documents all the way, because why the hell would I do that? But there's probably a ton more that we need to fix. And this amendment would ensure that the student body has the protections to not deal with the authoritarian tendencies of CSG that could impact them, whether it's in elections, student org funding, or any other way. So I hope that answers your question.
Yes, thank you.
Representative Florida, please do not curse. Representative Florida, go ahead.
Wait, sorry, repeat what you just said.
I said, please do not curse.
Oh, I didn't know hell is a curse. Are we counting that?
Yeah.
Heck. My apologies, Madam Chair.
Okay. Any other comments, questions? Vice Chair Lord Teasdale, go ahead.
Motion to discharge.
There's a motion on the floor. Is there a second? Is that a second? Representative Turner?
Yes.
Is there any objections? Hearing and seeing none. That passes. Moving on. So sorry. Let me get to my thing. Moving on, we have CA 16003. Better Call Saul Season 2. If the sponsor would like to introduce, please go ahead. So now.
In my opinion, it is the first great season of Better Call Saul, but also I wanted to hear somebody read that out loud. In regards to the actual bill itself, despite the funny title, it is actually a very extremely important bill. So if you look at the bill, and I'm still pulling it up myself, we are talking about student advocates. And it is no secret that whether in a certain someone's impeachment trial or any other trial or elections, a lot of people are struggling to find student advocates. And that is an immeasurable problem, especially for elections, because what happens is the elections are now bound by a timeline. And obviously, if we don't certify the elections, we have an extreme issue with democracy itself, in addition to all of our other issues. But so if you look at this bill, not only would it amend, although I'm trying to read my original language because there's so many amendments on this, not only would it amend the clause of the, what is it called? The student rights section, but it would add an entire new section to student rights, which basically would guarantee that anyone, whether they're filing an original complaint or they're on defense, the right to counsel. Because one thing the court has done is said that on offense, you don't get a right to counsel, which is a major problem. If somebody is a victim of student government or an individual or a student organization and they want to file a complaint, the court right now says, oh, we don't have to do that to you. We don't have to give you an advocate. And this is not to, of course, target the court in any way, because technically they're right. There is no clause that requires them to do that. I think it's in the spirit of the right to due process, but it doesn't say it explicitly. So this change in constitutional amendment would make it explicit that any student who falls under our governing documents would have the right to request counsel for offensive actions, even if they don't have a single word of the complaint written. If they have an idea and it is actionable under the rules after consulting with an advocate, they can do it. And the court is legally, but I guess legally, technically, they're required to assign them an advocate. And it seems we have a ton of amendments here, hopefully good ones. I haven't read them yet. I've been very busy, but it's extremely important that we pass at least the original version, although I'm open to amendments, assuming they're good amendments. And so I believe I have a co-sponsor if they would like to add anything.
Yes, thank you. The whereas.
Representative Neely, you have 1 minute,
Yes.
just for clarification.
Okay. So the whereas clauses are still not finished despite requests, but I have made some amendments to hopefully improve the language and organization. So I'm just going to motion to accept all of my amendments.
Is there a second? Representative Bookout, to your question, yes, it could be tabled. Is there a second to accept all of Neely's amendments to the document?
Point of information, I guess, directed to the chair. I'm wondering if Ms. Neely could briefly just point out, like break down what each amendment does real quick.
She is saying that she wants to accept all of her amendments.
I will object, but only on the condition that I would appreciate an explanation first as to why.
Okay. That motion does not pass then. But we have to have a hand vote. All those, Representative Bookout, is that a point of information question?
It's a question. Sorry. Is there a way, since this bill is very unfinished, that we can push, unless there are further questions, we can push for next meeting introduction until a lot of this stuff gets worked out?
Yes, but that would have to be a motion you make after the hand vote.
Okay, thank you. I appreciate that.
So we have to vote on the amendments first.
Yep.
Point of personal privilege.
Yes.
I'm just wondering what time is the next committee, because so that we can like be cognizant.
1 p.m. And for reference, I will be leaving around 11:40. So John will be taking over the meeting. Let's get back to the hand vote, y'all. All those in favor, please raise your hand for accepting all of Neely's amendments. John, did you get that?
Yes.
All those who are against, please raise your hand now. Okay. Please lower your hands. All those who are abstending, please raise your hand. Okay. Lower your hands.
With vote 1 yes, 1 no, and 2 abstention, the amendments are not passed.
there any other questions for the sponsor? Representative Florito, please go ahead.
I'm just going to make a comment in that I think that this bill is important, although like the other 002, it would not take effect even if we did pass it literally on Tuesday until the, what is it called? Certification of the election in the fall. And even though I do want to pass bills in one meetings for the most part, this is such an important bill that I think it's fine to both have it go to second reads in August. So I just wanted to make that comment.
I have a question for the sponsor. I understand that you would like to pass things in one meeting for efficiency and whatnot, but what I don't understand is passing them now when it won't even go in effect until later. And secondly, passing them now when majority of it is not finished yet and multiple representatives are saying it's not finished. What is the benefit of that? Because once it's passed, you can't edit it.
That's a great question. I would say for one, the more stuff we pass now, the less we have to deal with at second reads. And I'm going to be passing, or at least introducing, a lot of bills this year. And I'm assuming a lot of other people are too. So the sooner we pass it, the less long your meetings will be. I'm doing it not just as a favor, but it's just efficient. Secondly, this bill was finished. The amendments were not my amendments to be made. The original bill literally was just like a 2-line change. So in addition to Ms. Neely's amendments actually just mostly being clerical for the most part, in addition to one pretty substantive amendment that we just passed, the bill itself is finished. If someone says it's unfinished, I would like to hear them explain why, rather than just say things out into the ether.
Okay. Representative Bookout, please go ahead.
Well, I was just going to say, going back to Representative Frida's comment about explaining why it's unfinished. Am I allowed to do this, just by the way?
Yes, you're allowed to
Oh,
answer a
okay,
question.
perfect.
You're allowed to ask a question.
Yeah, I'm just curious why, I guess at this point, there's just a lot of comments that are just really, really long, that are like paragraphs of debate kind of happening on this, in this. And I'm just kind of curious why, and this might, sorry, I'm trying to think of a way to phrase this that isn't going to be like a complete repeat. I just think it's probably better if we wait and get this resolved. I don't personally feel comfortable passing something with this many comments. So I guess, are you open to waiting a meeting and having more comments and amendments and all that before?
My apologies. I'm a certified yapper. I believe I did say that I'm willing to push this to August, although I say a lot of stuff. So my apologies if you didn't catch that. And my only advice is I hope people read the comments. I'm not saying you're not reading them. It's just obviously we got a lot of bills and a lot of things going on. So absolutely amenable to that. Thank you.
Representative Burrito, do you want to speak again? Your hand's up.
Sorry, my hand was up. My apologies.
Okay. Any other questions or comments for the sponsor? Okay. Can Representative Neely go ahead?
Motion to table.
There is a motion on the floor. Is there a second?
Point of information to the speaker. So table would not go back to assembly. Is that correct?
Yes, it would not go to the assembly. It would stay in committee. There is a motion on the floor. Can I get a second? Representative Bookout. Okay. Is there any objections?
I object.
Okay. Moving to a hand vote. All those in favor of tabling until next committee meeting, please raise your hand now.
Please lower your hands.
All those who are against, please raise your hand now. Please lower your hands. All those who are abstaining, please raise your hand. Please lower your hand.
With vote 3 yes, 0 no, and 2 abstention, this CA is tabled.
Okay. So we'll be tabled until the next committee meeting. Moving on. CA 1604, reinforce our rights and open our meetings amendment. Sponsor, if you would like to introduce, please go so ahead now.
More constitutional amendments. I am getting sick of them, although they are important. In all seriousness, though, this is important. So, like I said before, I know we got a long meeting, but constitutional amendments don't happen every day. So let's try to focus here. This bill itself would make it so that, as written, it's very simple. I would dare to see anybody say this is unfinished unless they have a very good amendment. It is a simple one-sentence change in Section 1. Freedom of speech under Article 8, student rights. The original clause starts as follows. Section 1, freedom of speech. Student governing bodies and organizations must not infringe upon any student's freedom of speech, freedom to publish, or freedom peaceably to assemble and seek redress of grievances. That is the original clause, and here is the amendment right after that. Student governing bodies and organizations must fully comply with the Open Meetings Act of the State of Michigan, defining student government as a public body pursuant to MCL 15.262 Section 2A and all subsequent clauses where applicable. And that clause there, I didn't know if I was allowed to put like a hyperlink in the Constitution or not, but if you go to that clause, that specifically defines what a public body is, and that falls under the jurisdiction of the Board of Regents, since our entire assembly is chartered by that. So obviously needs no introduction. People love censorship here, or at least they used to. Hopefully that's changed. And so this would make it that it is now not only a legal issue, which I believe it is, but it is explicitly in our Constitution that we have to follow that rule. I'm tired and sick of, or sick and tired, I guess we'll go with the right order, of basically us making these roundabout arguments and, oh, safety this, safety, that's nonsense. This is about rights. This is about what students have the right to do. And I'm sorry, people can be nice, people can be productive, but at the end of the day, if something's a right, it doesn't matter. Your feelings do not matter, period. And I know that's not exactly like something that a lot of people want to hear, but it's true. These rights here in Article 8, they're not up for debate. They can be up for interpretation, but the rights themselves exist, period. These 6 rights are absolute unless otherwise specified. That's the whole point of a right, unless it's so vague that it needs to be amended. So I think if the 16th Assembly wants to be different from the 15th, pass this, in addition to numerous other changes, I would say we need basically a whole overhaul of our rules, because we did so much damage, not just to CSG's reputation, but to democracy itself. I think it's no surprise that after our turnout peaked in 2018 at 25% and in the fall of 2023 at 23.8%, we are at half that now. Not even, 6 years later? And for the latter, that's not even 3 years later, and our turnout halved. I'm sorry, if you think that's unrelated, you are not living in the same reality that I am and the same reality that every other student is. And so my encouraging words that I will leave you off are as follows. Endorse this bill or sponsor it if you want to change it.
You are out of time.
Tried to estimate in my head.
And just as a reminder, please don't make overgeneralizations about the assembly body's opinions on things. It's just not nice. Let's be nice.
Point of order. Is that against the rules?
It can be against decorum.
Which specific rule is that?
Way within the code of conduct.
Which specific rule, though?
It's not necessarily against the rules, but let's just be nice. Can we?
I will do my best, Madam Chair.
Thank you. Mr. President, please go ahead.
What up? I love censorship and, fascism and all that. So
the main issue, I agree with the bill. The only issue is that the office of general counsel, the university's general counsel, has advised us that we aren't a public body as part of the Open Meetings Act. Now, this constitutional amendment, I'm pretty sure would be okay because we are saying that we are a public body, right? That's not an imposition being made by anybody else. However, the only possible point of contention that I would recommend the sponsor reach out to the Office of General Counsel to talk about is whether we are allowed to call ourselves a public body as defined in Michigan State Code and as it relates to the Open Meetings Act. I'm pretty sure it's okay, but it might not be.
Madam Chair, am I allowed to respond?
Yes.
Also, Madam Chair, how much time do we have for responses? I just want to be cognizant.
3 minutes in total.
Across all responses?
Across all responses,
Oh,
but
boy.
because nobody is a committee member right now, I'm just letting it go.
Well, you are the chair. Thank you. In regards to the president, that's a very important point. I would say, for one, just can you tell me how you get in contact with them? I would love to get in contact with these people so that we can make a case. But also, the second thing I would say, and this is both an ideological thing, but also I think a tactic, CSG needs to get in the habit of pushing the envelope. I want to be told by the university that, no, this is against the rules. So it becomes a circus. It should be. We should force their hand, say, hey, these are the rights of the student body that we want to protect, and you're telling us that we can't, even though we're a democratically elected body who takes basically taxes from students. I want them to step in and stop democracy because it forces their hand. And that is news if that happens. And so instead of, doing this whole liberal politics, which we've done basically for like the last 5 years, I'm not saying anybody here has done that. What we need to do is say, look, no, we're going to go and push this forward. If you want to stop us, come in and stop us, period. And if you think, I don't know, like that's like some kind of threat or something, like, no, it's just logic. If they say it might violate, well, let's find out. Let's find out. And so I yield.
Representative Torres de Navarro, please go ahead.
Thank you. I have a quick question, and then depending on that, I have some follow-up longer question. So when you say student, so in the beginning of the appendix A, under section 1, you're saying student governing bodies and organizations, etc. So I'm assuming governing bodies would be CSG, RSG, ESG, LSASG, etc. What would be organizations under this definition?
That's a fantastic question. I believe technically no org other than potentially another sponsored student organization would fall under that. The reason why it's in there is just to keep it with what is existing. But I would say that that's a great catch, and I'm happy somebody read my bill. That's great. And that we need to define what those organizations are because it's not defined elsewhere in the Constitution. The only reason I kept that language is because this bill is not to decide that. It's simply because the first sentence says the exact same thing, identical. So I wanted to keep it the same. But I will put a pin in that.
Yeah, so just to continue, my concern there is that if a student organization, for example, their e-board, or they just have a closed meeting to members, or etc., this is an organization that is more, I mean, it could literally be any organization. My concerns there is then would they be essentially mandated to open the meeting? And so I think making sure that that's not the case is very important. Whether or not it's legal slash in order, etc. For student government, I'll leave it up to other people to decide. I'm more so just coming from this organization perspective. But yeah.
Madam Chair, am I allowed to respond?
Go ahead. Sorry, I'm eating, guys.
No, I do that all the time. It's all good. So my advice is to read the Open Meetings Act. I don't know. It's a long bill, of course, but it is 13 pages. It's not crazy long. It defines everything pretty much that you need to know there. And if it doesn't, then that's an issue for state law, not us. I just sent it. Oh, shoot.
Mr. President.
I just sent it in the
please go
chat. Sorry.
ahead.
I was just gonna say, so student governing bodies, it might be student governing boards. I don't know. I'm pretty sure the Center for Campus Involvement in their manual of procedure has their own definition of student governing bodies, that CSG has zero jurisdiction over. If that's the case, then we can't dictate rules to them. So you could amend it to say like student governing bodies under the authority of this constitution or something. And the other thing I would say is that like you want to challenge admin, like go ahead. I've done it on plenty of issues, although albeit issues that issues that in my opinion are much more important as they relate to student safety. However, that's not what my concern was. My concern was that if it is thought of as OGC to be a violation of university policy, which it sounds really bad, and it's true, it is really bad, and it really makes me mad. But the fact of the matter is that we are to some degree limited by the universities, by the regents' neutrality ordinance. And if that's the case, we can't break away from the university in official decisions. Thus, we can't disagree with OGC's official interpretation and act on it, which would thus make it a violation of university policy and out of order. That's why I'm saying go to OGC and ask them, hey, is it a violation of university policy from us to break away from your interpretation? If we are breaking away from your interpretation, because if they are, then it's out of order. It's a violation of our rules.
Thank you, Mr. President. Representative Florito, you can go ahead.
I have 4 responses to that. One of them is I agree, but also the other 3 I very much disagree or I'm very confused. So let's go through them. First of all, I don't disagree with you about the student governing bodies and organizations, but it seems like this committee is mistaken. Please read the bill. That clause is directly just a copy and paste. I didn't write this. I didn't come up with that language of freedom of speech. If we want to amend that in this bill, we can, or we can do a separate bill. I don't really care either way. But you see, Nico, you would have to amend this part too, right up here. It's the identical language. But regardless of that, I'm happy to do that. I don't feel one way or the other. Regardless of that, the other stuff is like much more important things. I would ask, is this bill not important? And what is important? My third question back is the Regents Neutrality Ordinance. Can you please send the link to that in the chat and also tell us what specific clause of it you're citing? And my last question is, or I guess a repeated before is there a specific person or email that you are in contact with? And could you please share that with me? Thank you. I yield. I yield my time to President.
Mr. President, go ahead.
I'm not telling you my view. I'm just telling you what I was told. So like you can disagree with what I was told. And then as far as who from OGC to contact, just look up their office. I don't know. I'm not in contact with OGC. Usually when they're mad at me, they come to me. Give me a second. What was the other thing? Oh, about what I consider important. I said I thought there were things that were more important. I've broken away from admin when it comes to a student getting detained by ICE and making sure that student gets to safety. I've broken away from admin on a labor union's bargaining efforts that have resulted in a legal effort by the university, and I've broken away from the university, at least the official administration, as it relates to how police are supposed to act around specific individuals. Freedom of speech is important. I just haven't
really
broken away from admin on that because I think it's
news
really
to me.
important that for me, I'm speaking just for me. You guys can do whatever you want. I would rather, waste my goodwill with admin making sure a student isn't detained by ICE. Again, freedom of speech is incredibly important, and I support this bill if it's in order. That's it.
Representative Florida, you can go ahead.
I guess point of parliamentary inquiry. Am I allowed to ask President a follow-up question related to what he just said?
Is it a follow-up question in relation to the bill or his personal opinion?
No. It's, well, one of them is to his personal opinion, but the other
I
one is
want them
specific.
both.
Whoa, easy now, soldier.
Let him, Chair.
Okay.
Let him.
Okay.
Call me a
Well,
coward.
Point of order. She is the chair. You're the
Let's
president.
go.
No.
Elena, I'll fight you too.
Hey, point of order. That's a
Nico,
threat.
I see how you're looking, Nico. Don't you? I'll go over there.
He's losing it.
Summit, if you do not be quiet, I will kick you from this meeting, I swear.
It doesn't feel good when that happens, by the way.
Yes, you can ask him that question, but may I remind you, if it is something of a personal question that you can ask him outside of committee, I would do it then, because again, time, and we still have, I believe, 5 more bills to get through. If it is like in not actual relation, please do not ask him. And secondly, if everybody keeps yelling in my committee meeting, I will start muting people. I swear. So please, let's have decorum. Let's be professional. I understand people are tired and whatnot, but let's be professional here. Okay? This is very important. This is rules. Thank you. You can go ahead, Representative Filarito.
Thank you, Madam Chair. I will obey the rules. I am very, what is it called? Good at that. So I guess one question specifically is about you mentioned the Regions Neutrality Ordinance. I didn't quite get an answer. I just want the link to that. I could probably find it. I just want to make sure what I'm looking at is the right thing that UGC gave you. And if you could email that to me or send it in chat, whatever. And the second thing is, you mentioned about the students being detained by ICE, and obviously I think that is, in my opinion, inseparable from what this bill is adjacently dealing with. And my question to you is, are you aware that if the Open Meetings Act applied, it would protect the rights of a student who was being detained at one of our meetings from recording that ICE agent and or members of the assembly? That was a question to you.
Mr. President, please, I warn you, you can continue.
Yeah.
This is awesome. I'm having fun.
I know it applies all right. That's all I'll say. No, I will say one more thing. I think it is quite a stretch when a student is held in ICE detention, endures a hunger strike, goes to their labor union asking for help, gets charged $38,000 by the university, gets told they're not going to graduate, gets harassed by ICE every day, has to wear an ankle bracelet in their house, and gets threatened to be sent back to their home in Cameroon that is currently encountering civil strife that none of us in this room could ever imagine. This is not related to the bill. However, I will say that let's refrain from making comparisons between those situations. While it is completely true that freedom of speech is vital for ensuring that those protections remain in place and criticizing when those protections are violated. I agree. Let's just refrain from comparing specific situations and actions.
Okay, any other questions for the sponsor?
Point of information to the chair,
What
I
is your
guess.
point
Is
of
the chair aware that I did not initiate any comparison talk? I was simply curious as to what other priorities this administration has for CSG.
Okay. Continuing forward, does anybody else have any questions for the sponsor? Representative Neely, please go ahead.
Yes, would people be amenable to tabling for one meeting so we can talk to the office of the general counsel and get these concerns resolved?
Representative Florida.
Um, uh, we can still do that. I don't think we have to pass Tuesday. I'm just saying if we table it, then it doesn't get brought up Tuesday. And I think this is so important that it needs to be covered by the news. So if we could just discharge it to assembly, my intent is not to pass this Tuesday, to be clear.
It still can be brought up in August, though, because we have 2 meetings in August. So it can be brought up the second meeting in August as a first read. I would like to clarify.
Yes.
If we do
oh,
table
sorry.
it.
Was that a question
And
to me
even then,
or a
no,
comment to
that
me?
was a point of information.
Oh, gotcha. Well, I'll have a point of information. I think every opportunity we can use the media to get this word out is important. And I hope that the chair would be aware of that.
Did you have anything else you wanted to say, Representative Florida? Your hand's still raised.
Yes. Oh, shoot. Sorry, I misclicked. I just opened my stock app. Motion to discharge the assembly.
There is a motion on the floor. Is there a second? Is there no?
To clarify, this does not mean it will pass. It just will be brought up so that the Daily would cover it. And also I'm going to cover it.
Representative Bookout, is that a second?
No, it's a motion to table.
You can't do a motion with an emotion.
Oh,
Secondly, the motion to discharge this to the assembly does fail with a lack of a second. Representative Bookout.
can I motion now to table? Is that within rules?
I do believe the bill dies, for so to speak, if it doesn't have
Point of order.
a-
The bill is not
Second.
dead. Right now, it would automatically be, what is it called? Isn't it automatic in the operating procedures, I believe? That it would be
Yeah,
re-referred?
automatically tabled. So it is already tabled.
I just want to clarify, it's not going to die, right? Because I don't want to reintroduce things over and over again.
I believe it. Mr. President,
I have a point of information. Are we discussing what happens when a bill gets tabled or just when it doesn't get approved? When it gets tabled, it doesn't, there's a difference between a bill getting tabled and postponed, to my knowledge. To my knowledge, please look into it if I'm wrong. I'm pretty sure when a bill gets tabled, when a bill gets tabled, it has to, you have to email the speaker asking that you want it to be reintroduced at whatever time you want. If a bill gets postponed, it automatically gets considered at a future meeting of the motioner's choosing.
okay, well, the motion to send it to the assembly just failed.
Oh, wait. Are we not in a motion now? Like the motion's dead? Point of information, I guess?
Then the motion's dead.
Okay, got it.
The bill is dead, yeah.
I'd like to make a motion.
Okay. Go ahead.
Motion to postpone to the next Rules Committee meeting, which I would believe is August, right?
Yes. There's a motion on the floor. Is there a second?
Literally doing, okay. I was like, I'm literally doing what you guys want, right? Okay, thank you.
Is there any objections?
God, this
Hearing and
place
seeing
is going
none,
to kill me.
This is postponed until the next.
This is shaving
Committee
years off
meeting.
my life.
Moving forward. What is this? AR 16025, CSG endowment codification and safeguards. Sponsors, if you would like to introduce, please go ahead now. You have 3 minutes.
I'll go, and Steven can chip in whenever he wants. So, let me find the bill. I'm sorry. I'm sorry. Endowment safeguards. Okay. So this resolution, so we have for context, CSG has two endowments. They were created without Assembly's explicit permission, without ever telling them. Money was put into them, $10,000 about, without ever telling Assembly. Wasn't me. I'm sorry. Won't do it again. But we think it's important that the endowment not just be dictated by, the president's whims in the EDF, and that it should be regulated by Assembly more than anything. So, this is what this bill does: is it creates a mechanism by which CSG authorizes additions to the principal in the endowments, withdrawals from the principal, reinvestments, proceed transfers, all of that. You can look at the different voting thresholds if you would like. Please, hate to sound like Tyler, but read the bill. And then the other thing I would say is that, just because I know it's confusing, is that there are
Read the bill.
two different
Read the
endowments
bill.
that we have. We have
Read the bill. Put on your reading
quasi-endowment,
glasses. Read that bill.
and we have a quasi endowment. And the quasi endowment, what that means is that we just can't, or we are allowed to take out the principal. So whatever money we put into it, we're allowed to take out. The true endowment, we can never take out what we put into the principal. That's all I'm saying. So yeah, that's all I got.
Okay. Treasurer Asante, would you like to add anything?
Nope. Big Boss did a very good job explaining it, but essentially, guys, an endowment was created by the last administration. This is a fact. There is money sitting in a quasi endowment right now. This is a fact. So essentially, what we are trying to do here is set up the procedure for the endowment to become an official CSG account and govern the ways in which money can be put in and out of it. Essentially, the structure of it is for it to just basically be like any other budget amendment where it requires like a 2/3 majority. And so basically what this is trying to include not just exec, but assembly in the discussion too, so that we're all governing this money in the best interest of students. That is essentially the bill. If there are any like questions about how much is in this account, what these accounts look like, how this was structured initially, to my knowledge, I can answer that as well. But like Big Boss said, please read the bill. Thank you.
Yes. Read that bill. Read that bill. Yes.
Excuse me, any questions for the sponsor? Representative Burrito, please go ahead.
Yeah, just a quick one. I was just wondering. I guess this would be to the sponsors first. If they could just include like maybe the immediate clause before and after each change, just so we can see what we're looking at. Obviously, it's not like the end of the world or anything, but like for example, before endowment, I would just want to know what 4.4 is and 5, so it's just like we can see where it is in the bill. Although I do appreciate the fact that you got rid of most of the walls of text that are not relevant. If you guys can make those changes, they're not even amendments. I don't think it's clerical, but we can make it a friendly amendment. That would be helpful, both for my ADHD and also my OCD.
Yeah, sure. I can read that.
Thank you, guys. Otherwise, bill looks pretty good.
Okay. Any other comments, questions for the speaker?
I have a motion real quick.
Go ahead.
Motion to recess for 2 minutes just so they can add those clauses real quick, and also we can take bathroom breaks.
I'm going to object to that personally.
Well, I tried.
Um,
I'll withdraw my motion just so we don't have to vote on it.
Thank you. Any other comments, questions for the speaker? I mean, sponsors, excuse me. Representative Florida, go ahead.
Yeah, I was just wondering, what does true endowment mean? Is that like a legal term or just like literal? Like, I'm just curious.
Am I
Mr. President, yep, you can
okay? Thank
respond.
Yeah, it's a legal term. So the defining term of a true endowment is that you cannot take the principal out of it. So whatever money you put into the endowment, you can't take out. You can take out the proceeds, you can take out the profits it makes. You just can't take out the money you initially invested into it. And then a quasi endowment is separate from that because you can take out the money. So for example, the money we have in CSG, right? Some of it was put into a true endowment, some in a quasi endowment. Whatever was put in the true endowment just can't be taken out. Stephen can correct me or add on to anything. I yield the rest of my time to Stephen.
Essentially, the language. So, Tyler, to address your question, the true endowment is how CSG can receive external donations for our endowment. We as CSG cannot put any money into the true endowment. So all of our money right now is in the quasi endowment. The quasi endowment is basically our mechanism for contributing to endowment, where we can say we want to put in CSG money in CSG funds. We can also receive donations to that too as well, but that's not really relevant because we're going to funnel all the money through donation wise into the true endowment. That's why we need to take true, because there are two distinctive accounts that make up the entire endowment. Does that make sense? Yep.
Point of information though, my part is still true. My part is still true.
No, still true. Still true.
They're not fighting, guys. They're friends.
Representative Florida, go ahead.
Oh, I just wanted to make a quick point of information, I guess, to the chair, just saying that even though I do know the answers to a lot of these questions, I didn't know that one, but I know a lot of them. The point of why I'm asking so many of these is because I want the people watching, but also in general, the new members, to understand why we do things so that it doesn't just become a monotonous routine that means nothing. This is important, and obviously this one's directly important and impactful to our financials. So.
Okay. Treasurer Asante, please go ahead. If you're raising your hand for something.
Sorry, Chair, I'm not raising my hand. Go ahead.
Okay. Any other comments, questions? If not, I'm going to motion to discharge this to the assembly.
I have just one real quick one.
Okay. Is it very important?
I mean, yeah, it's before the assembly. It's about the assembly.
Okay, go ahead.
I'm just wondering, is the intent to pass this in the August meeting, I'm guessing, after more amendments are made?
Yes, I will answer that point of information that was posted within the Slack itself.
Oh, my apologies. Sorry, I was outside. I couldn't really read the Slack because I have it on dark mode and I gave up.
Okay. I motion to discharge this to the assembly. Is there a second? Is that a formal second, Representative Florida? Is there any objections? Hearing and seeing none, this is discharged to the assembly. Moving on to the next piece of legislation. AR 16-026, Assembly Recording Policies Act. Sponsor, if you would like to introduce, please go ahead.
Sorry, 1 second.
I'm muted. Thank you. So obviously recording is a very, I guess, widely or hotly discussed topic. And so, this is essentially to find sort of a middle ground, between, of course, respecting students' right to publish, whether that be an organization like the Michigan Daily or an individual student that just wants to perhaps start publishing themselves, as well as sort of addressing some valid concerns from assembly members on either like safety or just knowing that someone's recording. And so this is kind of trying to find a middle ground. And so kind of just to take you super briefly between everything here. And so it maintains the uh, um, existence of the closed door session or closed door meeting mechanism. And so committees can still go into closed meetings and votes of substance and recording cannot be allowed in these meetings. Okay. And then In addition to that, I would add that any individual attending a meeting, whether a member or of the public, so just Michigan Daily reporter, student, or an assembly member, must disclose their intent to the chair. So that could be like me or any of the other chairs, depending on the committee, at least 24 hours prior to the meeting. So that would be for this meeting, or let's say the finance meeting, that would have been yesterday at 1 p.m. Eastern. And then disclosure under this section has to be made in writing to the chair, so that can take any form, whether that's email, Slack, etc. The chair should acknowledge this back in writing. Any non-response to the chair for more than essentially more than 12 hours before, so that would be 1 a.m. Eastern. Obviously, you can respond the day before. Should be treated as acknowledgement. We could tighten that a bit to be like 3 hours or something like that. And then the chair of this meeting is permitted to remove the individual for failing to disclose a recording activity. So that would be that they did not say 24 hours in advance that they would record and they were found to be recording. And that authority should not be exercised in a manner that discriminates based off of anything in the Constitution, matters of political opinion, or membership to any student organization. So, for example, specifically targeting like a Michigan Daily Reporter, which is a student organization, or any university affiliation. Then it's saying that upon receiving notice of recording, the chair is responsible for announcing to all attendees that the audio or visual recording is taking place. And then, then there's sort of two exceptions, which are that the disclosure requirement should not apply to recording device, application, or tool used as a disability accommodation. And I see Aaron's comment there, and I agree. So we can potentially kind of work through that, figure something out there. And then the other exemption is that if you're not able to provide advance notice, you can then make request an exemption to the chair, and then that's put up to committee for a simple majority vote. And so essentially, that's sort of to just protect against, let's say, something's like last minute added to the agenda that is controversial or something like that, that would allow someone to still record or report on the meeting if needed. And then the last little bit is that if the chair decides, so let's say finance committee decided that they wanted to maintain an official recording of a committee meeting as sort of a secondary form of recording on top of the person recording the meeting, they can do that, and then that would only be available, must be made available to members of the assembly within a week of that meeting, and that would be only available to members of the assembly. So it'd just be available for internal purposes. So yeah. And with that, I'm done. Thank you.
Any comments or questions for the sponsor? Okay.
Sorry. I was trying to make one, unless you have one.
I was going to motion to discharge this to the assembly.
I guess
But
I
you
would.
can go ahead.
Okay, perfect. Are you withdrawing your motion? Or I guess you
Yes.
never made it. Sorry about that. Yeah, no, I think, so I guess first and foremost, I wanted to say that I know this is a long meeting, but this is one where I think we actually need to iron this out as much as possible and past Tuesday, because this is not just like, oh, a theoretical authoritarian. It would never happen in real life. It's literally happening to me right now. So let's.
I want to interject for a point of information for the new members. Bills have to be read twice. So even if this gets sent to the assembly as a whole body can gauge this by being in first reads, and then it has to be sent back for second reads, unless somebody motions to put it on business. So I would just like everybody in the meeting to know that even if this is sent to the assembly floor, it is most likely just going to be read and then get re-referred back to committee where we can iron out more things. I would like to say that because we have been in a meeting for close to 2 hours now. So just would like to say that for everybody that does not understand or in case had some confusion on that, because the way that this is being framed a little bit is reading as if it gets sent to the assembly now, it would be voted on, and it is not being voted on unless it is formally motioned for.
May I continue?
Yes.
Also, how much time do I have left?
That did not cut into your time. You have 2 minutes.
Thank you, Madam Chair. Anyways, And I pretty much second everything the chair just said, except for the fact that I will be making that motion to pass this, obviously, assuming that we make good amendments first, since this is literally something that has been an issue for months. We need to end the cycle. Anyways, in regards to the bill itself, I like a great deal of what is being said here. Obviously, getting rid of the unconstitutional rules at the end, for one, saves people a court battle, saves me a court battle, saves Aiden Burke, even though Aiden Burke agrees with me, by the way, a court battle. And not only that, but it just is the right thing to do. In addition to that, there are some questions potentially about the disability accommodation. I guess in theory, it's not against like any sort of code or university policy. My only worry is that I guess my one question to Representative Torres Navarro is, couldn't anybody just say that I'm live streaming this meeting for a disability accommodation?
So my primary thing was there is that I didn't want to start getting into the whole like you have to send me specific documentation, put that very much like on the chairs. I want to put things more on the chairs, but okay. But I want to very much make sure that we're not putting the responsibility to like determine a disability accommodation in the chair position. I agree with like the comment that Aaron left, and I agree with what you just said, but um I I'm open to amending it that way. I just want to be cautious that um we're not putting it in the chair's responsibilities to determine whether or not someone has like a valid disability um reason to record a meeting. So that's more so my point. Um yeah.
Representative Florida, is he even there?
He is using the restroom. So
Oh, okay. With that being said, there is no other comments or questions. Is there any other comments or questions for the sponsors?
I have a
Sponsor,
motion.
excuse me. Go ahead.
I would like to accept. Let me see all of them real quick. I believe all of Representative Neely's amendments, because they're awesome.
Is that a formal motion?
Yes.
There's a motion on the floor. Is there a second?
I don't think there is any. The only amendments made by Rep. Neely right now is just the formatting at the bottom. Everything else.
My apologies. I thought that I
Yeah.
was doing the whole thing. My bad. I'll withdraw my amendment then. Well, actually, you know what? We'll keep it anyways. It's just formatting. Who cares?
Torres Navarra, is that a second?
I'm not a member of this committee, so I can't second.
There is no members of this committee right now, other
I
than
guess because
John
I'm a permanent
and me.
member of another one already. So
Point of order. Any member at any committee, at least historically in the rules, has been able to make motions. It was literally only last assembly when somebody was targeting me that changed. So you can make this motion, in my opinion. And it's up to the chair to rule on that.
Right now, because nobody is a committee member, anybody can make motions technically. But once permanent committee members have been made and assignments
That's not
have been
true.
made,
It's literally not true.
then it would need to be under yielded time. But
Point
that
of
is not
order.
right now.
Point of order. It says that nowhere in the rules, and it has never been the case until the previous parliamentarian just wanted me to not speak. It literally was never the case for 15 years of CSG. So I disagree with your interpretation, and there's no rule that says that.
I have a motion.
Go ahead.
I'm gonna motion. So I know this is also going to comms, so I'm gonna try to like maybe keep the ones that are a little bit more of that related. Or I'm just gonna try to pass 1.7.3 and
Point of
then
order. My amendment was still being considered, I believe. I apologize, Representative Torres de Navarro.
yeah, it's just okay.
What, Tyler, your amendment did not have a second, and it was a clerical edit.
Okay, sorry, my apologies. I'll withdraw.
Thank you.
So I'm
Go
gonna motion
ahead.
just to accept 1.7.1.2.1, which is the part that's talking about like just or non-discrimination, and then 1.7.3. Everything else I'm gonna leave to either comms for like or the actual assembly, just because some of the ones need to be edited, but I feel like those are kind of pretty straightforward. So
Can you repeat again? 1 point.
yes, I can highlight. So it's just these two. So
Okay.
1.7.2.1, which is adding that whole non-discrimination part, and then just adding that the announcement has to be either at the call to order, so like when you say this meeting's starting, or prior to the meeting, like on Slack or email.
Okay. There's a motion on the floor. Is there a second? I will second that myself, if not. Is there any objections?
But point of personal privilege, can you highlight the text that you were referring to? Like with your cursor? Thank you.
Is there any objections? Hearing and seeing none, I will make those changes. Representative Florito, go ahead.
That's just a quick comment. Although usually I'm against redundancies, like technically I believe adding this doesn't actually change anything since you're already not allowed to discriminate. I do think it's important since it seems people have forgotten that you're not allowed to discriminate. So I appreciate the amendment.
Okay. Any other comments or questions for the sponsor? Is that a question, Representative Florito?
Yep, just a quick one. Is your intent also to pass this Tuesday since I'm literally getting kicked out of office for this? The current rules?
Okay. I'm gonna make two things very clear. I'm writing this of my own volition. I'm not doing it because of any particular like recall motions or anything. I voted to keep the recall motion in the last meeting. So that I think indicates my, I guess, position on that. Um, More so it's just that I was very against this original resolution. And so this is something that I've been wanting to work on. And so I do not intend to pass this in the next meeting unless a majority of the
I'm literally
assembly
getting kicked out of
feels
office
the
for live
same.
streaming.
But
Or
I
they're not going to
myself, the
actually, but
sponsor of
they're
this
trying
bill,
to.
will not be motioning to pass this one meeting. I want this to go to another rules committee meeting. Is, for example, I want to work through that disability clause in this with some members, as well as just trying to iron out more concerns. I also want to hear what committee, maybe communications has more issues. So I do not plan on passing this on Tuesday unless some other member of the assembly motions and a majority feels the same way.
Representative Florito, is that a question?
Yeah, I got two questions for the previous representative. One, do you think somebody should be kicked out of office for live streaming? Two,
Okay, this is not an actual question.
it is a question, Madam Chair.
It is a question, but is it an actual question of the bill itself? It's not
The bill
related.
literally addresses live streaming and changes the rules on that. So unless you have a different rule that says that I can't ask this question, I'm going to ask it if that's okay. Can I continue?
Go ahead.
Thank you. So do you think somebody should be kicked out of office for live streaming? Two, when it comes to fundamental rights, do you think not taking a position on them is something that CSG should be in the regular habit of doing?
Point of information, Representative Torres de Navarro, you do not have to answer that question.
Point of
I'm gonna
information for the
answer
chair,
it.
it was two questions, and I want to know the answer to the first one at least, because that one's directly related to this bill.
He
don't have to
does
answer
not
anything,
have
though.
to answer. Yes, he does not have to answer.
CSG does that a lot.
I'm gonna answer. It's okay. When you're saying kicked out of office, I'm assuming removed from your entire position. For recording no, that's obviously how this bill is written. And then uh, I'm gonna be honest, I don't remember the second question. Can you repeat it really quickly?
Do you think CSG should get in the habit of not taking positions when it comes to fundamental student rights and wrongs? Like not saying it, like I don't take sides when it comes to literally things that are written verbatim in the Constitution. Should we not take positions?
But
You don't have to answer.
I don't even understand. The question is not even
I can go
it's not
slower.
even
This is what
related.
I mean, and
A,
this is
it's
not
not even
related
related to this
to.
resolution, which we've
This is
acknowledged.
unrelated.
Yeah,
We
it's
will
just
be moving forward. Representative Partland, please go ahead.
I'm gonna motion to discharge this to the assembly.
There's a motion on the floor. Is there a second? Representative Torres de Navarra, is that a second? Is there any objections? This is discharged to the assembly. Moving on. We have AR 16027, the Strategic Task Force Act. Mr. Speaker, if you would like to introduce, please go ahead. So now.
Hi everyone. I hope you're doing well, and are having a lovely summer so far. So yes, this is a resolution concerning our graduate task force. So last assembly in the 15th assembly, this was passed towards the end of the session, which this was a thought process that we would assemble together, graduate and professional students, to really meet in a task force manner to kind of talk about needs that they have for their respective community. Master's, PhD students, law students, med students, masters in social work. There's a vast amount of not only differences but needs that are needed for their respective communities as well. This was just passed towards the end of the session, so actually maintaining and creating new membership was going to be incredibly difficult. But now in the 16th session, we can do exactly this. It's really interesting. Actually, I had a conversation with the version of me at UNC Chapel Hill, Speaker Kelly. Speaker Kelly at UNC Chapel Hill really had an interesting
It's like he
conversation
has a
with me just
clone.
about the interesting differences in their advocacy that is had at kind of like their undergraduate and their graduate environment. So I think this equally just promotes that we can have hopefully a dedicated task force for our amazing graduate and professional students. And if this passes, then I'll follow along with recruiting membership and having a very active, amazing task force. But yes, I'm open to taking any questions or comments. So with that, I yield back to Madam Chair.
Thank you. Any comments or questions for the sponsor? Representative Florido, go ahead.
I'm gonna keep it quick. I'm gonna answer in like, I don't know, automatopoeia style. Banger. Keep up the good work, and let's talk about this at RSG too.
Awesome.
Representative Partland,
Motion to discharge to the assembly.
there's a motion on the floor. Representative Florido, is that a second? Is there any objections? Hearing and seeing none, this is discharged to the assembly. Moving on to business outside of introductions. Here we have the ethics code patches, Assembly Resolution 16016. Before you introduce Aaron, I want to ask everybody, how do I switch over the host tools to a different person? Because when I leave this meeting, if I don't do that, will be ended. So I need someone to tell me how to do that.
Recess for 2 minutes, I guess. Or what is it called? Yeah, recess for 2 minutes so we can figure this out.
There's a motion on the floor. Is there a second?
Otherwise, it's not a formal thing to fix it, and then we can't do it, and the meeting will end, even though we have plenty of business to discuss. So if somebody could second my motion, it doesn't mean you like me. It's fine.
John, was that a second?
Yes.
Okay. Is there any objections?
Sorry, I do have a point of order. I believe that if you depart Chair Mullins, we lose quorum.
John is still. Ooh, I have to double check that. Representative Bartland?
Point of order, did that motion pass?
Who said
It
that?
was
The recess motion?
I was asking for objections.
Oh, my
Did anybody
apologies. Sorry.
object? No objections? Okay, that passes. Representative Bartland?
Okay, so to make John the host, you just have to go to manage participants and then you can hover over his name, I think, and then you should be able to make him the host. And then as far as the quorum, from my understanding, any assembly voting member who isn't a part of another permanent committee currently counts towards quorum for committees because nobody's assigned a permanent committee yet. So Natalie, Andrea, and Aaron are all three members of this committee for quorum purposes until the speaker assigns everyone a permanent committee. And Tyler is also a member of this committee right now. So Nico is the only one who's not because he's a permanent committee member of finance.
Okay, that's what I thought. I figured as long as John was still here, that still counts. Since nobody has actual assignments. Perfect. I will be leaving y'all. Bless up. Thank you guys for staying here. But I have to go. I have way too much going on today. But thanks, guys. Hope you guys have a great day. John, treat everybody well. John's great. Y'all love John. I know y'all love John. So I hope this does not break once I exit this, but bye y'all.
John, this is your moment.
Okay.
I'm sorry.
It did not break, at least.
I
That's
upped the
at
pressure on
minimum.
him.
Apologies. I will be slightly slower as I am also taking some of the meeting notes. It's 12:02. I call the meeting back to order. We are at AR 16016 in our business. For the author, you can now introduce the bill.
Point of information for the chair. I believe
Yes.
you could delegate notes to someone else just if it's too difficult to do both.
I think I got it. It's okay. I just figured it out now. Thank you.
Uh,
Sorry, Representative, go ahead.
Thank you. So, yes, this is the ethics code patches, basically just expanding and improving upon the reforms we already made to the code of ethics to clarify some things. I understand there are some provisions that people have people have taken issue that people have taken issue with. That people have taken issue that people have taken issue with. So I am happy to talk about that, but just go over real quick what this is adding. Clarifying duties of members, including with respect to the budget, the operating procedures, the standing rules, and executive orders, expanding and clarifying the duties of the student judiciary. I know that Chair Mullins said she had some issues with that. I believe those have already been resolved, but one of the justices may also provide feedback before Tuesday. dereliction of duty, delinquency, proposal to make clear more of what everyone's responsibilities are, but I understand that, there may be some disagreement about that. So happy to talk about that and my thought process and just some other things. Contempt of judiciary, contempt of assembly, including incorporating our code of conduct. And yes, we do need to do this to get ahead of the question. It is according to a CSJ ruling. So, yeah, happy to take questions and comments.
The floor is now open for any questions, comments, concerns. Yes, Representative Bookout.
Hi, Erin. I hope you're doing well.
Yes.
I had a quick question just on a specific wording, just because I think it's a little vague and was wondering if we could. Oh God. I always forget things when I come up here to ask questions. God, so bad. It was just to make it a little less vague, because I do think that this potentially could be an issue. And I know some other people have noted 7.7.3. Otherwise, it's quote, otherwise interfering with the rights or duties of anyone involved in proceeding. I just think it's a little too broad and was wondering if that could be tightened up a little bit. I'm happy to like
I'd suggest that.
work with you on that if you want. It just is, I think, a little too broad.
I'm okay with striking that clause for now because there is a more general definition above, and then the sub clauses are just specific means of obstruction of justice. It's not limited to those specific examples. So I think that would be okay to just strike 7.7.3. Do you feel that, yeah, I hope that 7.7.1 and 7.7.2 are more clear as concrete examples of what obstruction of justice would look like.
Representative Bookout, do you want to respond to that comment?
Yeah, I was just gonna say, I think that would be great if you said you were okay with that. I just think that like 7.7 point, oh my god, 7.7.1, geez, and 2, I think are not as like they're a lot, they have the definition. So I think that would be great. So thank you, Erin. I appreciate that.
Representative Fiorito.
I will make that motion.
A motion has been made. Is there a second?
I'll second.
Okay, thank you. Are there any objections? Hearing and seeing none. Could someone help me accept those amendments at least? Okay, moving forward, Representative Torres de Navarra.
Thank you. So, I believe Aaron had made like a change. I'm okay. Let me retract. So, I'm going to be referring to 3.1.2, which is saying, that the assembly must patch a constitutionally and statutory compliant budget for each academic term. It used to say within 30 days after the start of that term. So, I like the way it's currently written. I think that's fine. I'm just adding introduction rather than proposal, and then also just adding committee to finance chair. Uh, and those are the only two changes, but I like the way it's currently written. Essentially, my original concern was that it would, if the treasurer does not want to introduce a budget, then it would be the assembly's fault that would happen. So the way our rules are currently written, it gives my position the responsibility to introduce a budget if the treasurer chooses not to or just doesn't. So the way it's currently written is fine, and I think
Yes.
those amendments are all good.
Yes, thank you. Yes, as I wrote it, I would be in support of that as well. This is not trying to detract anything from the treasurer or the finance chair at all. I'm simply intending to clarify the duty on the assembly side that it needs to actually vote on a budget once it is introduced. No, we have government shutdowns at the federal level and they're very disruptive. We do not need that in CSG.
That would kind of be awesome. I'm
Thank
not
you,
gonna lie.
Representative Fiorito.
Oh, shoot. Um, Actually, you know what? Never mind. Sorry, I'll withdraw my hand.
Thank you. Are there any other questions, comments, concerns for this bill?
Sorry, I remembered.
Representative Fiorito.
Yes, sorry, I just remembered what I was gonna say. So in regards to the specific clause, I believe it's the whereas clause here. I was just wondering, obviously, the Chair Mullins is not here, Parliamentary Mullins is not here. I guess instead of deciding on that amendment or not doing it, could we leave it? Would you be amenable to leaving it for assembly when she actually is back? Sorry, I asked that in a really crappy way. I'm very tired.
Yeah, Representative Neely, I believe a question has been directed to you.
Yes, I'm sorry, Representative Fiorito. Could you repeat the question?
I'll do it better this time. Sorry, I was meandering. Basically, under the whereas clause, it's the last one. Parliamentarian Mullins had an amendment. I was wondering, would you be amenable to just not even talking about it since she's not here, and then we can talk about it in assembly?
No, let's just pass it now. I will motion to make that amendment because it is simply a sentence structure edit. It's not substantive.
Okay, a motion has been made. Is there a second to the motion?
Second.
Thank you. Are there any objections? Hearing and seeing none, the motion to accept the amendment on the whereas clause is adopted. Any other comments, questions, or concerns? Representative Fiorito.
I'm very confused. So, oh, sorry, the date is wrong. I thought Treasurer Asante's comment was today, and he said he was going to be at rules, and then he's not here anymore. I'll withdraw then. Sorry, my apologies. I'm losing
Thank
it.
you, Representative Neely.
Yes, then I guess then I will motion to accept the amendments in 3.1.2 and 3.3.2.
There is a motion to accept those amendments. Is there a second to the motion?
Oh, shoot.
Representative Bookout, is that a second?
Yes.
Yes, thank you. Are there any objections? Here, Representative
Oh, I'm not
Fiorito,
objecting. I have a point of information.
Yes,
It's
sir.
important, though, and it'll save us a lot of time going forward. I should have made this earlier. Point of information. Is the chair aware that if you make a motion and say by unanimous consent, we don't need to second it because any objection would make it no longer unanimous? Are you aware of that, Mr. Chair?
Yes.
Excellent. I hope we can do that in the future.
Yeah, but considering our conversations, just to be cognizant of everyone's voting power.
I'm awesome.
Okay. Hearing and seeing none, those motion to accept amendments are adopted. Any other comments, questions, or concerns? Yes, Representative Fiorito.
Just one quick question to the sponsor. So I saw that you tagged the former Chief Justice Labizo, one of the good men, of course. I was wondering if he ever got back to you privately on this at all, whatever his question was.
I don't believe he's officially responded yet. It was fairly recently when I officially asked in the document, and I understand that
He's a good
people
man.
are busy.
He's a good man.
So there is a chance that they will respond before Tuesday, though. So I would not be opposed to I would not, so I would not be opposed to passing this so the assembly can take a look at it and we can always vote to send it back to committee if there are still unresolved concerns.
Representative Fiorito, would you like to respond?
Yeah, no, I agree with that. I think my advice is one of the rules I live by is don't make a decision unless you have to. And considering all the angles, especially if something this important, is prudent. And I hope we do that.
Thank you. Are there any other comments, questions, or concerns? Representative Fiorito, your hand is still raised.
Yep, I have more questions. I'll try to ask multiple so I don't have to go back and forth. In regards to what is it called? Sorry, I'm trying to focus. Namaste. Okay. In regards to the last comment about parliamentarian Mullins, it's the last one under 7.7.2. How will threats and intimidation be determined? Do you have an answer to that question? I think it's a fair question.
Yes, I believe it would be in the same way as we determine threats and intimidation outside the course of an official proceeding. So essentially making someone afraid that if they don't comply with what you want, that there will be consequences for them other than natural and reasonable consequences that may come from a specific policy position. Basically if someone is afraid of conscious retaliation, then that would be a threat or intimidation at the minimum. I'm sure the Michigan Code of Law has definitions as well.
Representative Fiorito, do you have a follow-up?
Yes, a couple of follow-ups, I guess. I would guess for one, I think 7.72 for one is not in our jurisdiction at all. I mean, if a court does not agree in advance that somebody's making a threat or intimidation, which is the idea, you should go to a court, get a personal protection order or whatever relevant order, and then enforce it, and CSG should do it after. I feel like that's the order of operations. This is cart before the horse. And secondly, I would argue that because it's not in our jurisdiction, that this clause, if it was left in the bill, would make it unconstitutional. So I think we should remove it or like significantly amend it. I'm down to amend it too, but as it's currently written, this is unconstitutional in my opinion. And I guess my only question to Rep. Neely is, would you be amenable to changing this somehow to make it constitutional?
No, I do not believe it is unconstitutional. It is upholding the purpose of the integrity of student judicial
Point of order.
and ethics proceedings, and it
Point
accords
of order
with
has been made.
CSJ's own rules about
Neely.
improper interference.
Representative Neely, I'm sorry, I'd like to interrupt you. Representative Fiorito, what is your point of order?
I'm going to read the part of the Constitution that I believe it's violating as currently written, since I think reading things is important. So if you look at this bill, specifically, I'm going to read the clause first of the proposal in 1616. Using threats, intimidation, coercion, force, harassment, badgering, bribery, or any other improper means to influence the testimony of a witness or the decision of any official with the authority to rule on factual, legal, or procedural questions. Doesn't sound bad in theory until you read the Constitution. And as follows, there is a clause in the Constitution under Section 5, due process. Students must enjoy the right of due process before any student judiciary, including the right to a speedy, fair, and impartial hearing, the right to confront accusers and witnesses, the right to competent counsel, a presumption of innocence in all disciplinary matters, freedom from cruel and unusual punishment, and the right to an appeal. A student must not be twice put in jeopardy for the same offense, nor compelled to serve as a witness against themselves. I think it's pretty clear that that is cruel and unusual punishment to basically not have a very clear definition of who decides what threats are, since I can tell you firsthand, I was accused of threatening someone, and I've never threatened anyone in my life, and that stood for weeks. So I think that's blatantly unconstitutional, and I would ask, at least in an advisory sense, for the chair of this meeting to say it's unconstitutional so that we can amend it or remove it. I yield.
What is the recommendation for the point of order?
that 7.72, as currently written, is unconstitutional, violating Section 5, due process, specifically cruel and unusual punishment, since the whole point of threats, intimidation, force is to be decided in a court of law, and that's not us. So that's why it's unconstitutional.
I disagree. It is part of our
I
own
asked the
rules
chair
and
that question.
procedure. It is it is part of
I
our
will
own
let-
rules and procedure, and the provision applies to CSG's own proceedings and not to courts of law.
Is that, Ms. Neely, is that your response to or the original question from
Yes,
Representative
it is
Fiorito?
yes, it is my response to Mr. Fiorito. And in my experience as the ethics chair, I have very strong reasons to believe this is necessary.
I guess, sorry, before you rule, I apologize, Mr. Chair. I just wanted to clarify one thing factually. Ms. Neely said it's not a matter of law. Intimidation is a legal code in the Michigan codes of state conduct. Coercion is also a crime. Harassment is a crime. Bribery is a crime. So we're citing 4 crimes here. So unless we're going to create our own statutes, it is a matter of law. And what Ms. Neely said is incorrect.
We have our
Fiorito-
own definitions up above in the Code of Ethics.
Representative Fiorito, would it help if this items were defined under this section?
Absolutely, Mr. Chair, and that's why I don't. It doesn't have to be a big fight. We could just amend it and make it clear. I don't want to have to kill things, since I do think these clauses are necessary. To be clear, Ms. Neely.
So as a decision to the order, I would recommend that Mr. Fiorito write a definition of this. Would that be amendment?
Since obviously we want to be cognizant of everyone's time, I will write an amendment to propose so that it can be reviewed Tuesday, just so we don't literally do it live. If that works with you, Ms. Neely. Not that you have to agree to my amendment. I'm just saying that that would be a good plan.
That would be acceptable.
Thank
Excellent.
you both for this discussion. Are there any other comments, questions, or concerns? Representative Fiorito, do you have another question?
Indeed, I do, Mr. Chair. And also, by the way, shout out to you. You're doing a good job chairing. Very fair and impartial. Just I respect it. But I wanted to specifically call about the contempt. I had a question of where are we defining contempt? Am I missing that definition here, Ms. Neely?
In what section?
So under section 7.2.1.2, and I believe it's referenced throughout this document, you mentioned contempt. I'm wondering, is there a specific definition of contempt other than 7.1? Because it doesn't really give us very much to go off of. And I would argue that because it's unclear, it is unconstitutional.
No member may defy the legitimate authority of the assembly or of any committee or other derivative body thereof. This was already in our code of ethics, and the legitimate authority, meaning the items that the rules the assembly passes for its own members, we have to abide by. And the contempt vote is an accountability mechanism when people cannot or will not abide by those rules.
Mr. Fiorito, do you have a response?
Yes. One, just because something's written in the code doesn't make it constitutional. For two, this is the other ones. If you want to say that I'm not making a solid argument as to why they're unconstitutional, this is pretty blatant disrespect. That violates literally half of the clauses in terms of freedom of association. Let's say I associate with a political party that it has
disrespect is not in 7.2.
Well, regardless, Ms. Neely, I'm speaking, but you can respond after. Also, I would like to reclaim my time on that. Anyways, regardless of that, it's in at least the context of your bill, and I think we should amend it before, I feel confident that if I took this to CSJ, they would overturn it. I don't want to have to do that. It's annoying, and it takes a long time to write those things, but I will if I have to. In addition to that, it also violates Section 1, disrespect, verbal disrespect, doesn't clarify either. And then contempt itself, because it's defined as disrespect, thereby de facto would also be unconstitutional, since you are defining it with the word disrespect, which in my experience is in no code of any law, civil court. Hell, I don't even think there's the word disrespect in like the region's bylaws to run their meetings. And if it's not in any other court, there's no precedent for it. And it's so vague that literally me going and disagreeing with you could be disrespectful, since apparently in chat sometimes people say my tone is disrespectful. I would say that 7.1 is unconstitutional as currently written. I would say 7.1.1 is also unconstitutional. And thereby, because they define what contempt is, the rest of the clauses that mention contempt in 7.2 are also unconstitutional. And like the other clause, I'd be happy to suggest amendments prior to Tuesday if that works with Ms. Neely.
Before Ms. Neely responds, I'd like to remind everyone to exercise some patience and caution with our language and decorum in the meeting. Representative Neely, do you want to respond to any of the comments, questions, or concerns?
Yes, this is simply clarifying proceedings. The contempt provisions were already passed and they were already amended with the concerns of President Lauf about disrespect. They were also cleared by Student General Counsel Burke. They are the application to CSG of the contempt of court and contempt of Congress proceedings in federal law. I did my research before writing this.
God, I hate it here.
I do not see any reason why it is inherently unconstitutional. And if there are any further questions or comments about this, I would encourage consultation with the Student General Counsel and or CSJ itself. The former Chief Justice Labazo explicitly cleared at least the first provision.
Representative Fiorito.
I don't know if I was yapping too long, but let's actually read what the Constitution says. I guess I'll read it out. You know what? I won't read the whole thing out. I'll just read the sections so it doesn't get annoying. But please actually read this. Article 8, Student Rights. Section 1, Freedom of Speech. Section 2, Freedom of Association. Section 3, Fair Regulation. Section 5, Due Process. Section 6, Equal Protection. If I am not clear already, disrespect is so vague and not legally defined that it would potentially be cruel and unusual punishment, which violates Section 5. And also, historically, this has been an issue at Michigan, but also many institutions across the United States. People are treated as disrespectful just because their vernacular is different. Maybe they come from a different culture, or English isn't their first language. And I would argue that violates Section 6, potentially, equal protection. Or let's say somebody has Tourette's syndrome, right? And they say a curse word in CSG or something. That could be called disrespectful, even though they have Tourette's. You know, it also violates Section 3 because, like I said before, it is so vague that literally anything could be disrespectful. Me breathing right now could be very disrespectful. I'm sure it is. And Section 2, Freedom of Association, like I said, if someone made a political party and named it something, provocative or whatever to target another political party, that could be considered disrespectful too. And Section 1, Freedom of Speech, which I don't think needs to be elaborated on. Ms. Neely, can you explain in detail why this is constitutional? Explain.
By analogy to the federal statutes and under clearance from our former Chief Justice. Further discussion can be had outside of committee. Amendments can be proposed, which we will discuss after they are proposed, and I am willing to consider amendments that are proposed in good faith.
Before I recognize Representative Fiorito, to expedite the discussion, Representative Neely had agreed to any proposal in amendments. Is this something that is also amendable? It seems like that.
No, not necessarily any amendment. I said I am open to discussing potential amendments. That does not mean that I will approve any amendment that someone wants to make.
Apologies for that, Representative Neely. Yes, agreed on that. Anyone who may want to propose an amendment can propose an amendment. Does not necessarily mean that the author will agree to it. Representative Fiorito, do you have any more comments, questions, concerns?
I do, unfortunately, because what Ms. Neely proposes sounds great, but the problem is the practical reality. So, for one, I would like you to actually say, like, the specific statutes of federal law that you're referring to in your previous response. For two, If you could provide any written details of former Chief Justice Lobizo, like what his opinion was in detail, that would be helpful. If not, if he didn't give you anything written, please try to get in contact with him to come to a meeting, preferably next meeting. And we could yield him time to speak if he's free, hopefully. If not, maybe outside of committee. And my third question is, you said good faith. And trust me, I love being good faith. Problem is, every time I make an objection, and it seems like any kind of disagreement in CSG is treated as bad faith. So I wanted to make it clear that even though I'm disagreeing with you, I am disagreeing with you in good faith because my intentions are exactly what I am saying they are, which is what good faith is. So I guess the first two are questions. The last one was a comment. Do you have answers to the first two?
Justice Labazo has been tagged on the document, and we will wait for him to get back to us. In the interests of time, I will not be entertaining this further in the committee setting.
Thank you, Representative Neely. Representative Fiorito.
My first question literally was just ignored, although I apologize, I was yapping. You said federal law, like these statutes are so clear apparently that your bill is not unconstitutional. It shouldn't be that hard to cite them in the bill. What statutes of federal law are you talking about?
Representative Neely, would you like to respond?
I do not believe it necessary to answer that question.
Thank you. Moving forward, Representative Fiorito, do you have any other comments, questions, or concerns?
I have a comment, and it's that if you are telling me that the reason your bill is constitutional is that it was verified under federal law, and you can't even say a single law of which one it is, I'm sorry, but that is not good practice, especially for an ethics chair, to pass bills, cite federal law, and not cite the specific law. Just say it out there. That is not good practice for CSG, and we need to do better, and I hope we can in the future. I yield.
Thank you, Representative Fiorito. Just again, a reminder to everyone, I love the discussions, but let's keep as much decorum within this body. Are there any other comments, questions, or concerns? Hearing and seeing none, I will motion to discharge this to the Assembly. Is there a second?
Second.
Representative Fiorito, is that also a second? Yes. Yep. Is there any objection? Okay, great. Hearing and seeing none, this resolution is discharged to Assembly. We're moving on now to our final item of business, AR 16017. Let's have the author introduce the resolution. Representative Neely.
Point of personal privilege. Ms. Neely, if you're speaking right now, you're muted.
Okay, thank you. As I said, Acting Chair Laura Tiso, thank you for allowing me to introduce this bill. This is simply making some further edits to the proceeding for actually going through with the complaint process, including clarification of the anonymity provisions and the reporting provisions. It also creates whoa, wait. Within five more days, the assemblies.
Point of order, real quick. I apologize, Ms. Neely. Mr. Chair, did we have quorum on the last vote? And also, what the heck is quorum?
We do. So any of the non-permanent members, except for Representative Torres de Navarra, because he is a permanent member of the Finance Committee. So any other non-permanent members here could constitute a quorum. So we do have quorum. Representative Neely, you can continue.
Yes, thank you. This also outlines a process for the administration of voluntary resolution plans, or essentially binding mediation in the interest of avoiding unnecessary escalation of conflict or imposition of involuntary sanctions. It would have to be agreed to by the parties, and then it would be binding. The ethics committee's role would be to facilitate that mediation process. I have also been in some talks with SGC Burke about the pre-screening process. I understand that assembly members may have questions and comments about that, and I will answer whatever I can answer, but yes, if you'd like to talk to about further reforms to the pre-screening process, then please talk to me, Vice Chair Shevsky, and SGC Burke outside of this meeting.
Thank you, Representative Neely. Representative Fiorito.
Thank you, Ms. Neely, for the introduction. I guess first off, I wanted to say that this obviously is a good change for the most part, based on my understanding, unless I misread the bill. It is a no-brainer. I think it is also readily apparent the instances this is in reference to. I'm not going to be like vaguely like, oh, who knows who it was. We had so much conflict, not just with me and others, but plenty of other interpersonal things that just never got addressed. And I got to be honest, my comments here are as follows. Talking to someone is not very hard. And obviously, like if somebody, regardless of if they're actually doing something, illegal or wrong, or if they're just not being nice and it makes you uncomfortable or like gives you, what is it called? Like anxiety. Obviously, you don't have to subject yourself to that. I understand that. For me personally, I had to take a step back in what was it, like June for a little bit, because I had health stuff going on with PTSD symptoms, literally because of CSG. So I had to take a step back, and there's nothing wrong with that. In regards to the bill, though, I think that we should treat this as not just a change and an option, but the standard. Like, people need to resolve their conflicts, because here's the thing. It's so hard to hate someone when you actually speak to them as a person. It's so easy to hate an idea. It's so easy to hate a character, but it is so incredibly hard to hate a person. And this change, literally, if it was in place in the last assembly, I got to be honest, my impeachment wouldn't have happened. A lot of these recording bans probably wouldn't have happened, or at least they would have been like compromises. And probably tens of hours, maybe even hundreds of hours of just nonsense would have been saved if this was in place. And I think it's a fantastic change. And it has my complete endorsement. Not that Ms. Nealon might not want it from me, but it's a great change, and I yield.
Thank you. Any other comments, questions, or concerns? Okay, great. Seeing and hearing none, I'm going to motion this to discharge to assembly. Is there a second? Is there a second?
Yes.
Representative? Thank you. Any objections? Hearing and seeing none, this resolution is discharged to assembly. That concludes our business for today. We'll now move on to our last part of this meeting, which is the general discussion. I'd first like to thank everyone for staying put for the almost 3-hour discussion that we had for this Rules Committee. In response to Representative Fiorito's comment on the 10 a.m. meeting, yes, that will definitely change in relation to who are going to be the permanent members for the fall, once fall starts. So once the rules members are set and or identified, we'll definitely send out a separate survey of which is the most amenable time for everyone. I will now entertain anyone who wishes to speak for general discussion. Oh, sorry. Yes, Representative Fiorito.
Actually, wait, are we still technically meeting, or can I just yap and say stuff?
This is now a general discussion, so technically you can yap, but
I'll try not to.
And cognizant of the time, please do not. Yes.
Yeah. No. I don't want to take us directly to one. No, thank you. But I just wanted to say I have a lot of bills in the pipeline, and I'm sure like a lot of people here, even if they agree with my bills, are going to be too they don't want to put their name on a bill, even if it's a good idea, just because they don't want to be yelled at, which is fair. But here's a couple of bills I have in the pipeline, and I wanted to read them out. If anyone finds any of these interesting, not like the whole bills, just the titles, in general, ideas, so that if you like any of these, ping me, I guess, email me. I don't know, send a carrier pigeon to me. So I have this for rules. What is it called? Oh, goodness gracious. Sorry, I'm opening the wrong document. Give me a second. Gotcha. There we go. So a big one that I wanted to do is CSJ technically doesn't have like a yes or no on whether they follow the federal rules of civil procedure in court. And so I think obviously it's a no-brainer that like following those rules in terms of general structure is just a good thing to do, since that's our court system that we work under technically. But also another thing that was a great point that was made to me that I didn't even think about is the fact that our law students, especially my advocates who won in court pretty well, they are being taught year one. All year one law students are being taught federal rules of civil procedure. So if we're looking for student advocates in the future, this would be huge, because it's like, oh, it's the same system. It's not any questions about it. So that's one bill. Obviously, another one that I have been talking about for a while is what is it called? Soft C criteria, student org funding criteria, where if they buy something that isn't like a one-time purchase, so not food, something like I don't know, a folding table, right? If they had that, they should get, what is it called? Like some level reimbursed, so they can increase their borrowing limit, which would thereby incentivize, what is it called? More people to buy reusable things. And I think that would be huge. Also, I have a third bill that I was working on is, sorry, my eyes are not working very well. Oh, there we go. Make it a compiled code requirement, to basically have a non-binding ballot for every single future election, like the 2024 winter elections, where it's an open-ended question where they have 8 responses and they can say how they heard of CSG, because that data is the single most valuable thing we have to engage the student body. Despite SoftC being awesome, if you put the raw number of students who apply for SoftC versus the raw number of students who vote in the elections, it is exponentially higher, the number of voters. Despite our bad turnout, it is the single best way to engage the student body. So I think that change would be huge. Before I continue, I have plenty of other bills that I've been working on, but I want to stop with just those 3 for now, just in case anybody has any questions about any of them, or I don't know, thinks they're awful ideas.
Thank you. Since we are in discussion, please direct your comments to Representative Fiorito in private. Is there anyone who would like to speak during general discussion? Representative Partland.
Motion to adjourn.
Okay, yeah, no need to motion. Seeing and hearing no other items or speakers for general discussion. The time now is 12:42, and the Rules Committee meeting is adjourned. Thank you so much, everyone.
Appreciate you guys. Thank you. Thank you so much, Mr. Chair. We will be back with another stream in 18 minutes. Next committee is at 18 minutes. Wow. Final couple thoughts here. 1, CSG is very authoritarian. Oh, my Lord. 2, I cooked. I think I did really well, although sometimes I was a little too energetic with my words and stumbling over myself. I didn't get enough sleep. It happens. Overall, I think, though, I would give myself an 8 out of 10 grade, which is a yellow flannel if I was an album being reviewed by Mr. Fantano. What else? God, we have a lot of work to do. Yeah. I guess... Honestly, I was going to try and yap until 12:45, but I need a break because this next meeting is also going to be long and annoying. So we'll see you in 17 minutes. Just have notifications on for the channel. Tap subscribe at the top of your screen, somewhere up here. See where my mouse is. Hit subscribe. Double tap the whole screen to like it. And when you hit the subscribe button, if you go to the channel homepage, you can hit notifications on. We will be covering every single public CSG meeting this way, or at least as much as I possibly can without exhausting myself, although I'm going to hire other people. So, yeah, democracy dies in darkness. Some of these people suck. I know I make a lot of jokes, but genuinely, this is a big threat of authoritarianism, and we need to stop it, and we will. Follow GLU.